Senators, when the House rose, the Sovereign Wealth Fund of St. Lucia bill was passed. Honorable Leader of Government Business.
Thank you, Madam President. Madam President, I beg to present for second reading a bill shortly entitled Criminal Code Amendment. Madam President, I will proceed with some explanation because this bill had, like the first one this morning, previously been circulated. There's quite a lot of content that is related to that bill. I will attempt to be as concise, but make sure that I include the important details. First of all, I need to establish, Madam President, the purpose for this bill coming to this House. And the main purpose, Madam President, is to improve the efficiency of our justice system. I think we will all agree that our justice system, as it stands, has a number of inefficiencies, a number of things that can cause persons who are perpetrators or persons who have had allegations made against them, who have to answer to their wrongdoing, having their justice delayed. And the justice delayed, justice denied cliche can come into play. And so this is one of the attempts, in addition to a number of other things that this government has done. We believe that will help to make the system or the process more efficient. And so there are some key issues that will be featured in this bill. One, Madam President, as I mentioned, is the efficiency with which matters can be addressed, and hopefully the shorter space of time or the shorter period of time within which justice can be dispensed, of course, without compromising the process. Also, Madam President, there are some advantages that I will try to refer to and to point out. So let me first of all, Madam President, establish the main objective for this bill. And that is that the bill basically provides a legal framework that hopefully, and we believe, is going to help reduce the backlog of cases that we have in our system and make our criminal justice system more efficient and more time, let's put it this way, more make it better or easier or quicker for justice to be dispensed. Madam President, I want to provide what I would refer to as a definition. What exactly is this bill doing? It really is replacing or seeking to replace or to have a judge alone type trial as an option to what we have as the jury type trial. Now, what exactly is the judge alone trial, Madam President? It refers to a trial where a sitting judge alone determines questions of fact and law and is empowered to determine guilt or innocence of the accused. And that is a key factor. The bill also, Madam President, if I can just let's say add to some of the features, I want to make reference to some of the jurisdictions where this method or this judge alone trial practice is being used. And we have to always look at what is best practice and what has worked elsewhere. There are a number of jurisdictions, some of them regional, some of them outside of the region, where this particular approach has been tried, including England and Wales, that's outside of the region, Northern Ireland, in Canada, it has been tried in New Zealand, some of the Australian states like New South Wales, Queensland, Western Australia, South Australia, Australian Capital Territory, the United States, India, and South Africa. Madam President, within the region, this system has been, or is being used, or has been tried in Antigua and Barbuda, in Jamaica, in the Cayman Islands, in Belize, in Trinidad and Tobago, and further afield, in Russia, Singapore, Pakistan, Malaysia, and Sweden. So all of these jurisdictions have tested it, or it's been tried and used in these jurisdictions, and they have achieved or realized certain levels of success. In what situations would that type of trial be best suited? It is suggested that it is best suited, and that is based on a consultation that was held with some legal luminaries, including our own Attorney General. It is best suited for high-profile cases, for very serious cases, for long and complex cases with technical, that include technical or trivial matters, as well as pre-trial publicity, prejudice, graphic evidence, extension of media coverage, intimidation or threat jurors, geographical challenges. So, Madam President, there are a number of different examples where that approach has been found to work and is being used. Madam President, there are lots of processes involved in using that approach, and I think in some cases we have to examine some of the processes. For example, it involves the prosecution, which is also one of the processes or one of the features of a jury trial. The prosecution in that case may apply to the court for judge-alone trial and in certain circumstances. And these circumstances include danger of jury tampering or intimidating of witnesses, material witness may be afraid of or unwilling to give evidence before a jury. The case may involve criminal gang elements, and the complexity and length of the trial is likely to be burdensome in the case of a jury trial. Madam President, there is the no appeal issue that may come up in the discussion, and I would like to share here that no appeal shall lie against the order of a judge granting or refusing an application for a judge-alone trial. Now, not a virtual complainant, but an accused can be given a choice as to whether or not they want to stand a judge-alone trial, or if they want to go through the regular jury process. So there is opportunity for them to reconsider. Then, Madam President, if I may share on the trial itself, the structure of the trial by a judge alone is the same as is or exists for the jury. It would involve, and some of the legal people here might be more familiar with this, they might have been in a court to have witnessed it themselves. It will involve the opening speech, the prosecution calling the witness, the defense cross-examining the witness, the close of the prosecution's case, the defense that may make a no-case submission. If rejected, the defense can be called upon to answer. So it also involves the defense entitlement to testify or remain silent or call a witness. It may involve the addresses and then a decision by the court. All of these rules, Madam President, also apply in the jury, and the evidence will apply. The judge in this case addresses the issue of admissibility, and parties may be called upon to make submissions, to argue, and on any legal issues that may arise. Madam President, what are the powers of the judge-alone trial with reference to the Court of Appeal? It has the same powers in relation to the criminal appeals in respect of jury trials. So you can do the same, you can appeal, just like somebody would have done in a jury trial. And there are a number of other questions that can be raised. For example, the issue of case management and the principles of case management. The duty of the trial judge is to hold the case management before the trial. And the objective of this case management is to ensure that each case is dealt with efficiently and expeditiously by actively managing each case. And of course, both parties must actively assist the court, that is both the prosecution and the accused. There are some other features, Madam President, I can refer to in cases where, in the region where we have the jurisdictions where we have the judge alone versus those we have without judges. And if we look at the region, there are some, like I mentioned, Antigua, Belize, and the Cayman Islands, Jamaica, and so on. But we have some countries that do not yet, or are not yet using it. And St. Lucia falls among these, along with Barbados, Bermuda, Dominica, Guyana, Montserrat, and St. Vincent and the Grenadines. I suspect a lot of them will follow very soon, because with the regional issue we are having with criminal activity on the rise, they will probably find that this is an option to help increase the efficiency with which they dispense justice. Madam President, what are some of the advantages in using that particular approach? One of them is that it shortens the time within which the trial is held. It provides a shorter period of time for the trial to be had, and some of the processes that can be very time consuming through that method can make the trial time shorter. And some of them would include the tendering of witness statements by expert evidence, the summaries of facts, mid-trial evidentiary and legal issues without the interruption and the risk of discharge. Deliberation processes are being streamlined for counsel. There is no risk of disruption from absent jurors, which is, in our small jurisdiction, a challenge. When you have jurors, Madam President, they are our peers, and many of them are people who have regular lives, and sometimes you can have delays because you can't find jurors, and it may not be because of any deliberate reason, but that's the reality. And that's one of the shortcomings of the juror-type trial that you can avoid with that method. The flexibility of sitting hours, again, because of the jurors, when jurors are involved, they may have limitations as to what time of day and how available they can get. This allows for you to be more flexible, and streamlining of cross-examination is also one of the options that you have. Also, a few more of the advantages would be under the shorter period of time, would be there would be no jury directions, no jury expenses because you have to pay them. Streamline of the opening and closing addresses, witnesses called by availability rather than chronology, better management of unusual conduct, and the trial is less likely to be aborted. These would be some of the advantages that we can do with in terms of the being more expeditious in the dispensation of justice. With reference to the efficiency that I mentioned with judge-alone trials, there are a couple, well, at least one example I could reference, and that's in the case of New Zealand, where the issue of sexual assaults is one of those that has been found to have yielded some results. So in that case, from the opening statement, which is where the case started, to the summing up of the trial, it would take about 4 and a half, up to 30 jury trials took about 4.5 days. Now, that level of efficiency would not have been possible if they had gone the other way. So whereas it would have taken 4 to 5 days using the jury method, it would have taken about 2 days to complete the judge alone trial period. Just adding to the idea of more efficient. So it almost cuts the period of time by about half. There's also the point referencing that same New Zealand example, where now you might say New Zealand is a little far away, but sometimes best practice is applicable, not because of geographic or contextual location and so on, but because of the similarities in the process. The time spent between the alleged offense and the trial was significantly reduced because due to the absence of the pre-trial procedural complexities in the jury trials. Again, that is one less inhibiting factor. So, Madam President, I just think I can probably mention 2 or 3 other examples with regard to the judge alone trial advantages as compared to the jury trial process. Madam, it is noted that it reduces the backlog, which is what we're trying to achieve. It creates a more expeditious criminal justice system. It saves expense, which we can do with as a small island. It is best for long and complex cases. It avoids chances of perversion or perverse verdict. And that's something, every time I hear perverting verdict, I get very nervous because I don't think that would make many of us happy. So anything that would reduce that would be welcome. Jurors may be influenced by improper evidence if the judge tells them to disregard it. So in that case, the juror's discretion and so on and all of that can be removed. It guards against jury exposure to pre-trial publicity, protecting in a small island like ours. Everybody knows everybody. Someone might just discover that you're a juror on their case, and you know what that can mean. It's less formal. It has a less formal feel, and it makes it less intimidating to the accused than it is for a jury trial. It avoids prejudice that the jury may bring, prejudices that include race, gender. Can you well imagine a single mother as a juror on a case for child support? You know, I'm just thinking. Human elements may come in. Sorry? Yes, you might have a lady, she has 3 children, the boyfriend didn't feed them, and then she's a juror on a case where a fella is not paying child support. You can't help but bring in your own human element. Clarity in the expertise of the trial process, impartiality. So a lot of those, Madam President, are reasons why we believe that this method or this approach will help to contribute to a serious problem that we have in this country that we cannot deny, and that is the backlog of cases that we have had over the years, and how this approach can help to reduce that backlog and make the justice system a little more efficient, a little fairer, and especially not only to the accused, but also to the virtual complainant, because sometimes we believe that when the justice is delayed, it's the person who is accused who might be on remand and suffering. But sometimes people need to bring closure to a situation, and because it is still in the courts and pending over and over, they have to go back and forth. It can be very frustrating for a virtual complainant who has had a matter, especially matters that are sensitive. And I don't want to go into the graphic details of some of those that may involve people's emotions, people's integrity, people's own dignity, that you have to be going back and forth, and that can lead to frustration and eventual, degradation of character. So I believe, in a nutshell, Madam President, that this approach has an intention, and that is to reduce the backlog of the cases that we have in the courts and to make our system more efficient. And for that reason, I ask that this chamber sees it necessary to give approval to that amendment. Thank you.
Senators, the question is that the Criminal Code Amendment Bill be read a second time. Senator Lee.
Thank you, Madam President. Just a few words on this bill and a few observations with regard to that. The criminal justice system as currently exists is really a sort of a balancing act. As the Honorable Leader of Government Business noted, you are attempting to ensure that the accused is given a fair trial within a reasonable time, and being a fair trial means that he's not being railroaded into guilt. But on the other side, you have the interest of society and the virtual complainant who has actually suffered an injury. And so the process of our criminal justice system is a matter of sifting the facts to determine what has occurred and then determining what is a fit and proper punishment or way of remediating that injury to society. Traditionally, that process has been bifurcated or separated. So you have a jury who will determine matters of fact. The jury is the one that determines what happened, when it happened, and to whom it happened. And you'd have the judge who will determine issues of law, whether certain evidence is admissible, whether the elements of the crime have been made out, and he will direct the jury to that end. And then obviously determining what the punishment or the outcome of the result, of the verdict would be. Now, that jury trial that we have become very familiar with has existed in various forms from time immemorial, but is largely codified in its, or at least began its current structure in 1215 in the Magna Carta in England, whereby King John, as he was at the time, was faced by a revolt by his peers, and I say peers, I mean the lords of the land, who demanded that rather than the sort of arbitrary king's justice which existed at the time, there had to be a system of trial where their peers, meaning the other lords at the time, would sit in judgment of them rather than the arbitrary decisions of the king. It was stated in the Magna Carta that no free man may suffer punishment without the lawful judgment of his peers. And from that concept, the idea of your peers standing in judgment of you, we have come to the modern jury trial system, where between 12 or 9 or 12 jurors, depending on the nature of the offense you're facing, are selected to sit in judgment of the accused. Now, the strength of the jury system, in some ways, is also its weakness. The idea is you get a number of very randomly selected persons who have no connection with the accused other than that they are similarly citizens and hopefully have very little legal knowledge. The idea being that somehow if you have too much knowledge of the legal system, it might pervert your ability to listen to the facts and not prejudge them to some extent. And then I'll get to how that then forms part of the weaknesses of our jury system as operates in a small island like St. Lucia. But on the flip side of that, when you're taking persons just off the street who have absolutely no knowledge in some cases of the legal system, and oftentimes it's their first instance or interaction with the legal system at all, and especially if it's a very complex matter, they have very little understanding of what their role is, what they're supposed to be doing, and there's the temptation to either A, prejudge the matter, or go along with whatever the strongest personality in the group tends to say or do. And so oftentimes you'll have the jury being swayed by persons who've either had previous experience or just have that sort of forceful personality. In some ways that is for the positive, because it gives, like I said, the defense the ability to really tailor their defense to ordinary persons and not have to deal too much with the nitty-gritty and the complexity of the legal terms. But by the same token, as I said, on the other side of that, it means sometimes they miss a lot of the detail. And so there have been a lot of discussion as to the strengths and weaknesses of jury trials. It has, as I pointed out, been considered a cornerstone, however, of our judicial system and our criminal justice system. And this is true for pretty much all the common law jurisdictions, so the United Kingdom, Scotland, the USA, all of the English-speaking Caribbean. We all have this basic jury trial system, and trial attorneys tend to hold very strongly to that because they're aware that they can sway a jury based on your performance, based on your ability to connect with the jury, and based on your ability to communicate more effectively than the other side. That being said, there's a lot of inherent inefficiencies in a jury system. As the leader of government business pointed out, just the mere selection process can often take a very long time. You have trials being aborted just because you cannot get a sufficient number of jurors being empaneled, because just calling persons to jury duty is just the beginning. You then have to qualify them, ensure that they are able to sit on the particular trial. Both the prosecution and the defense have a number of peremptory challenges that they can make. They just don't like the look of a particular juror. They can ask for that juror to be removed, as well as you have challenges for cause. And so oftentimes you can have a jury panel being whittled down and you have to start the process again because no sufficient jurors are found. As well, criminal trials can be very, very long. It's very easy for a criminal trial to extend past 8 weeks. And to have a bunch of persons empaneled away from their work and being kept, so to speak, in secure facilities for such an extended period of time obviously does put a lot of stress on government resources and can put stress on the persons as well, because especially if it's a high-profile matter where you've had to sequester the jury, that means they're not able to speak to their family, they're not able to speak to their friends, there's no recreation in the traditional sense. And all of these things can put stress on the jurors and color their decision-making process. As I noted, in a small island like St. Lucia, you will imagine that the jury pool is a very limited size. And so you have the problem, one, of making sure you find jurors who do not know or are not connected in any way with the trial or with the defendants or any of the witnesses. If it's a very high-profile matter, you often have the issue of pre-trial publicity, whereas everybody knows who did it. Because one of the problems, I remember very early on sitting in on a murder matter, well, when I say very early on, during my legal training, sitting in a murder matter and sort of listening just to the comments in the gallery. And the persons in the gallery were absolutely sure that the guilty person, that the accused, and this is before any real evidence had been led, was guilty of the crime. Why? Some because they were from the area, they knew him and they knew he was a problem person in the area. Others just felt he looked like a criminal and therefore had to be guilty. And if this is what the ordinary persons are saying and feeling and believing, being aware that the jury is being taken out of these persons, oftentimes the similar sentiments would be expressed, or at least potentially be expressed by the jury. And we must remember that under our criminal justice system, justice must not only be done, but has to be seen to be done. So we have to make sure at every stage the process and the procedure is without question. And so, various suggestions have been made for means of improving and correcting some of the defects that has been seen in the jury system. And this judge-alone trials, have existed, as again the leader of government business has pointed out, in a number of other jurisdictions for a number of years. In fact, Trinidad had passed legislation in 2017, although it only became effective in 2019, for judge-alone trials. And in some ways, again, there were a lot of good things that did happen during COVID, which I think, unfortunately, we've lost a lot of it. But the impetus for this really did come up during COVID, when it was realized that whereas civil matters were able to continue and proceed because civil matters in St. Lucia are heard only by a judge, and you could have these hearings taking place virtually. It was a completely different issue to try to empanel a jury virtually, have the jury in one location, the judge in another location, the defense and prosecution in another location. That became unworkable. And so the trials, or the travails, I should say, of the COVID-19 situation gave an impetus for us to move towards judge-only trials. And the learned, my leader of government business, has pointed out a number of the benefits of a judge-only trial, largely being the efficiency of it. That you have a single judge who can hear the matter from start to finish. He has the legal expertise, because one of the issues and one of the very fertile grounds for appeal is often that the trial judge has misdirected the jury. And part of that is because the trial judge has to explain, often in ways that are contrary to common sense, how the jury should interpret the facts. And for example, ID identification is often one where common sense tells you, but I see somebody, I know the person, I must have recognized them. Whereas the directions make it clear that people often mistake persons. So often, we're walking downtown and we want to hail somebody, have our hand up, I've already hailed the person, only to realize that it's not the person. And so ID evidence in particular is very tricky. But you have a situation where you're trying to make everyday persons understand, contrary to what a lot of them would understand, that because the witness said he recognized the person, that is in and of itself not necessarily sufficient to convict. And so often criminal law in particular has a lot of these sort of contrary to what we would consider common sense aspects, which a jury being instructed by a judge may not get. But on the other side, one of the disadvantages of it is that you are now giving a sole person the full role of the trial process. They must not only consider and listen to all the evidence, they have to make decisions as regards to law and the admissibility of evidence. And one of the issues is, whereas with a jury trial, the judge can ensure that certain evidence is not heard by the jury. So if an issue of admissibility arises, the jury will often be taken outside. The judge will hear the issues in their absence and make a ruling. In this case, you have a judge who has to hear all the evidence and then decide whether it's admissible or not. And whereas they are trained, they are humans. And it is possible that, or the potential does exist, that there will be some perverting because I've heard all the evidence, that I may not be able to carve out the elements that I need to carve out in coming to my decision. But of course there is a right of appeal, which also we'll get to because this bill does deal with it. So to look again at the bill itself, because I like to go to the bill and go through some of the issues as I see it. The bill creates the opportunity, and I must point out from the beginning, it is not abolishing trial by jury. At least that's how I read this bill. That it is trying to add another arrow in the bow of the justice system to allow matters where it's appropriate to be heard by a judge alone. And there are three bases on which that can happen. The accused, on the advice of their attorney, having considered everything, can decide, I'm going to have a judge alone trial. The prosecution can make an application based on very specific circumstances, which I'll go through just now. Can make an application to the court for a judge alone trial to be held. And a judge, again, when certain things have occurred, can decide on notice to the parties that they are going to have a judge alone trial. The primary concern where the prosecution makes the application is to ensure the integrity of the trial process. So what is going to be section 874A(2) says that the prosecution may make an application for trial by judge alone to the court where an indictment has been filed against an accused person and trial has not commenced on the following grounds. So it's important to note that when the prosecution wants to make this application, it has to be made before the trial has actually commenced. That in view of the nature and circumstances of the case, there's a danger of jury tampering or intimidation of witnesses. Witnesses afraid or unwilling to give evidence before a jury. There's a likelihood that if a jury is selected, pre-trial publicity may influence the decision of the court. That the case involves a criminal gang element and would be properly tried without a jury. The complexity and length of the trial, or both, is likely to make the trial so burdensome to the jury that the interest of justice requires the trial to be conducted without a jury. Now, I'm sure we can think of instances where most of these things would apply. There's often the threat that witnesses will be injured, bribed. I think the celebrated Vibes Cartel trial, which came to its very long and winding end recently, is a very good example of where perhaps a judge alone trial may have been beneficial, because there were tangible threats at one point as well as attempts to bribe the jury in the matter, which the prosecution and the judge, for whatever reason, decided to ignore. But the courts held that that was sufficiently damaging to the whole trial process to justify a retrial to be held. And ultimately it was decided, given the length of time he had been on remand, essentially, and convicted, that they would not proceed with a rehearing, and he was released following that process. The complexity of the trial. We have in this this chamber passed a number of pieces of legislation regarding particularly money laundering, proceeds of crime. These sort of crimes tend to be very, very sophisticated and involve a lot of very technical evidence, which, to be honest, even as an attorney, sometimes I get very lost in. So again, having a judge, especially a judge who has a background in finance or the ability to understand accounting and forensic accounting, is better suited to go through the evidence and make a determination of guilt in that situation, as opposed to some random people who may have never heard of a trial balance, a profit and loss account, or any of those aspects of tax or accounts, and therefore ill-suited to judge these sorts of very complex matters. It also provides that the judge may, at their own instance, as I indicated, decide that to proceed with a jury trial, a judge alone trial, following a situation where during a trial by jury, any of these issues has arisen, and the judge has decided that it was either A, the jury should be discharged and the matter continued either as a judge alone trial, or a new trial should be ordered but continue as a judge alone trial, given the risk of the same instances occurring. The one concern that I do have arises at section 9 of the Act, which will be amending section 923 of this Criminal Code Act, or the Criminal Code of St. Lucia, which provides that a written decision is to be given within 7 days of the verdict. That is at section 9(7). Well, 7 and 8. And the reason for that I'm raising, I don't want us to go and create the same problem we're trying to get out of. We have recognized that there is a very woeful lack of resources in our criminal justice system in particular, which has led to a huge backlog in criminal trials. Part of the move, or the motivation of the move to judge-alone trials, is to speed up the process and make it more efficient. Judges are allowed 24 hours to make the decision, and then are expected to do or give a decision within 7 days. And I appreciate the need for urgency, but I don't want to create a situation where we are creating an unrealistic expectation that judges will be able to meet this demand and provide a full Because it's not just a matter of giving the order. They have to give reasons, an explanation of how they've come to this. So how I've come to the decision, as well as how I've come to the, not just the verdict, but how I've come to the sentence that's being passed. So I would like perhaps for either an extension of time to be given so that there's a little bit more time for the judge to do and fulfill that. Agreed. Again, I don't want to create moral hazard by giving too much time and then the judges just figure I have time to relax and do it. But I want us to be realistic in the time that we're providing for them to comply with the section, as well as putting the government side on notice that merely providing for this in and of itself will have an incremental improvement, but it will not be a panacea to the problems we face. There's still the requirement and the need to put the resources into the criminal justice system to ensure that judges have we have enough judges, especially if you're moving to a system where judges have to hear trials and do it on their own, that we have enough judges to handle those. B, have judicial research assistants who can assist them, particularly where judges have to make determinations on points of law, so that they can do these things more quickly and move the process along. And then to also assist them in terms of putting together their judgments and their orders following the trial. I want to bring to the attention of the House Section 10, which is the insertion of new sections 974A and 974B, and in particular 974B, which is headed Appeals. And 974B1, again, is very compendious in setting out where an accused person can either with the consent or the leave of the court appeal a matter, or whether they have a right of appeal as of right. But I most particularly want to point out subsection 2, which is creating a right for the prosecution to appeal criminal matters. Now, this is actually revolutionary for us because this is not something that has existed previously in our laws. Before, the only right of appeal lay with an accused. And basically, once you had a sentence had been passed, you were the only person who could appeal that. There was a risk in appealing sentence because there was the possibility that the prosecution could then persuade the court to increase your sentence. But generally, if you decided not to appeal, that was the end of the matter. This, however, now creates the possibility of the prosecution, without the leave of the Court of Appeal, appealing a decision on the basis that it was erroneous in law, which is a very wide power, and I will await to see how that plays out in practice. And then with the leave of the Court of Appeal, they have the right to then appeal a sentence on the basis that it was manifestly inadequate or was wrong in law. So, for example, on a murder trial, on a manslaughter conviction, if the court decided to sentence the person to 6 months, given the nature of the crime and the various factors, the prosecution may decide that that was insufficient and would be able, under this section, to appeal that the sentence, and ask the court to expand or to increase it. And I just wanted to point that out because, as I stated, that is a dramatic move for us and implementation of a hitherto unknown power for the prosecution. But all in all, I believe that this is a positive step. I think the legal profession on a whole has accepted that this is a direction in which we need to move for various reasons. The efficiency being one, the security and integrity of the system being two. And I wanted to point out it's important that for the justice system to work, and I was having interesting conversation with my colleague senator earlier, and we were remarking on some of the developments in the US with regard to the justice system and the system of laws generally. And the point is that our system of laws only really works to the extent that persons have faith and believe in it. We have heard oftentimes that persons are losing faith in our criminal justice system because they find it takes too long for matters to be heard, that it is too easy to tamper with the process and get witnesses to withdraw their evidence, that there are often sensitive matters that persons don't necessarily want to have heard before a jury. And so this act will enable us to hopefully shore up persons' confidence in our justice system and help the fight against crime. Because a lot of the fight against crime is that confidence, one, in the police, and two, not just that the police will do their job and investigate, but once they finish that process, that the criminal justice system, or the trial process, will result in a fair result, whether it's an acquittal or a conviction, that the process itself is fair, and part of that fairness has to be the speed and efficiency with which matters come to trial. And so with those few observations, Madam President, I hope that this will assist us in moving things forward in a positive direction. Thank you.
Senator Fede.
Thank you, Madam President. Madam President, I rise with mixed emotions to comment on this amendment. Madam President, this amendment merges or proposed to merge the responsibilities of juries and judges as currently obtained. The jury, Madam President, in our structure of government, which seeks and is built strongly on the principle of the separation of duties, which is why we have the judiciary, the executive, and we have the legislature here in the Parliament. But even within the important arm of the judiciary, the people who structured and conceived our democracy saw it fitting to realize that even within the judiciary, that it is important to also have further separation of duties, whereby you've got the judge that will examine the law and the sentences of cases, and where the jury will examine the facts of a case and arrive at a verdict. Madam President, today we are proposing a major departure from a construct of our democracy that we hold sacred over the years. Madam President, I gather from the statement by the leader of government business that there is an effort to quicken the pace of various cases. Madam President, I am very concerned that in our haste to quicken the pace of cases, that we don't compromise the quality of justice that is being rendered to individuals, Madam President. We're talking about criminal cases. Individuals can be brought before the courts for serious and heinous accusations such as rape, murder, manslaughter, and a whole host of very serious accusations. And so, Madam President, it is crucial that when you stand in the court and you seek to defend yourself, that every assurance is given by the system that the quality of justice is not compromised at the expense of moving cases faster and further along. That is an objective that the opposition holds sacred. And so therefore, Madam President, we remain concerned about this move from that standpoint. Madam President, other legal views have suggested that solving the backlog of cases that is inherent to St. Lucia's reality may not necessarily require this, but may require, and I want to refer to a paper written in the year 2000 by Sir Dennis Byron, and the paper is entitled Fast and Fair Trials, and it deals with the strategic case management procedures in a courtroom, Madam President. It suggests, Madam President, quite profoundly, that judges, magistrates, and other personnel within the judiciary must instead look towards a more strategic use of courtrooms. It goes on to suggest, Madam President, that in instances where matters coming before the court might not be considered as heinous or serious crimes, and those, I don't want to use the word trivial to trivialize any case, because every case is important, and that's why we live in a democracy. But the point is for less important cases, beg your pardon? Oh, I thank you for the assistance, Madam President. Less complex cases, I love that. I thank you, I'll borrow that phrase. And so less complex cases be accommodated via other avenues rather than the courtroom. One legal view that is suggested, Madam President, as we seek to address the problem. But while the leader of government business told us, Madam President, that the court or the judiciary system is inefficient, or that justice is often delayed, what he didn't go on to do is to spell out what exactly he meant by that. Could he have meant, Madam President, in his opening statement, that 76% of the inmates at Bordelais are on remand without trial? Could he have meant that? Could he, Madam President, have noted that the incessant complaints by the DPP office of inadequate facilities, mold infestation, a lack of air conditioning within the DPP office, where the staff, Madam President, has often complained? Madam President, it is for the leader of government business to tell us in greater detail what he meant by an efficient judiciary. Madam President, did the leader of government business mean that a recommendation by the DPP at a press conference as recent as a year ago, where the DPP suggests that there should be an independent body to investigate cases against police officers or complaints brought against them, that recommendation is still not forthcoming? Is that what the leader of government business meant by the inefficiencies of our court system? Madam President, as it stands, the police investigates itself. It is very, very difficult, Madam President, for you to get a matter against a police officer to be brought before the courts. And so therefore, at its most recent press conference, the DPP suggested that there should be an independent body to investigate the police. At the same press conference, the DPP indicated, Madam President, that when it came to a certain matter, that he had recommended to the police that an arrest and a charge should be made. But as the system stands now, the police commissioner has or reserves the right to refuse the advice given to him by the DPP. And so, while the DPP, in his view, felt that he would have had sufficient information for there to be an arrest and charge of a police officer who's accused of a certain crime, the police commissioner reserves the right to either accept or reject the DPP's advice. It was a police officer in this instance, but in another instance, it could be your case that we're talking about. It could be a matter that you are seeking justice about. It could be a matter concerning the death of a loved one, a family member who has been riddled with bullets in their bodies, laying in their own blood in the streets of our city. Madam President, the judiciary have often clamored for better facilities, and the halls of justice seems to have become the project of injustice. We still await, Madam President, after great fanfare, after a situation where the government went and made this big opening that we're going to build the halls of justice, it looks like the government has now abandoned the old site of the old courtroom, and they were going to have two buildings alongside each other, and this was going to be the best amalgamation of courtrooms for our judges, giving them better facilities. I have heard no update from the leader of government business on that project, but we wait his rebuttal, because I would like to know whether the judiciary, Madam President, is still going to have the building in the old courtroom site next to the Catholic Church, next to the cathedral, or has the church finally stood up to the government and said, no way, Jose. It is for the leader of government business to tell us the facts. Madam President, these are the things that need to happen if we're going to have a more efficient justice system. You can't have the DPP's office without air conditioning. You can't have the DPP's office with mold. You can't come to implement the halls of justice and then the project ran afoul. What has happened to the project? Where is the new location? When is the new timeline? When is the new halls of justice going to be completed? Have the cost been affected? Do we have a new drawings? What is going on? Give the public an update. What we see instead, Madam President, like we have seen when it's about economic development or development in other areas, we see a very piecemeal patch approach from the government. We bring this now, bring that there. And there seems to be no coherence in what this government is attempting to do. But yet, Madam President, they expect the opposition to come here and blindly support every measure that they bring to this House for debate. I want to say, Madam President, that the opposition, we behave in a lot more coherent manner than the government is purporting. Madam President, as we speak, we are presiding over a crime crisis in our country. Our country, Madam President, continues to be one of the highest homicide rates in the Caribbean. We continue, Madam President, to see our youth languish in the jail cells at Border Lake. Madam President, we continue to see our young women shot in broad daylight. We see that young men are shot even in the Derek Walcott Square, Madam President. We record year after year consistently over 70 homicides, Madam President. But yet the government tells us that everything is under control. Everything is not under control. The people of St. Lucia They need justice. And I don't have any confidence, Madam President, that this government is capable of bringing them quality justice, bringing them fair justice. So, Madam President, this amendment by itself cannot solve the problem that we face. This amendment, Madam President, is just another piecemeal approach, another talking point by the administration to pretend as if they are doing something about the problems that exist. And I hear the senator, the independent senator, suggested or implied as if there would have been some consultation with the legal fraternity. But Madam President, my bigger question is, how much consultation was done about the people who will be the ones on the receiving end of the justice system's services? How many community meetings have you had in Jacmel? How many community discussions have you had in Ancillary? How many community meetings have you had in the town of Soufrière, so that the people of St. Lucia can know that what you're planning to do is to give a judge carte blanche to become chief cook and bottle washer in the courtroom system? That's what you're attempting to do. So whilst the opposition sympathizes with you, and whilst we want to support you, but like everything else that come to the House, they lack details. Details are lacking. And so we can't just come willy-nilly and say, oh, let's do this, because we're more serious than that. We're more serious people than that. And so, Madam President, this is a crucial, crucial step that our country is making here today. And I know while we don't have the votes to stop this from happening, we would like to encourage the government to have more consultation on this important matter. Madam President, already there's a lack of public confidence in the judicial system. You know what the people, the man on the street, believe about politicians and judges and lawyers and you know what they believe, Madam President? They believe that they are unsavory characters. That's what they believe. And so we must do everything to give people confidence that every single chamber of our democracy is working well. We must give people every confidence that when they step into a courtroom, that our major priority is not to fast-track cases, but to give them the quality dispensation of justice. That assurance must be made. And unless that assurance is made, it becomes very difficult for us to have a fully inclusive judiciary, where the man on the street has confidence in what is taking place. You ask most people about the court system, and they will tell you it's a farce. That's where we're at in this country. And so, Madam President, more consultation should have happened to say to people that we are going to Parliament to amend a bill to remove, in instances, to give the judges the right alone to make the decision to do the job of the jury. This is a very small amendment, but fundamental to the dispensation of justice. Fundamental. There's a reason why we have separation of duties. And now we are merging everything into one and bestowing the power in the courtroom on very serious crimes. This is not the civil code we're amending, this is the criminal code. Very serious crimes. Some of these crimes, Madam President, people can be given jail sentences for the rest of their lives. That's what we're talking about here. You can go to jail for the rest of your life. And rather than making sure, and I noticed when he was mentioning the countries that have done this, I noticed that he has mentioned very few countries. He went all the way to Australia and New Zealand. I have not heard one single Caribbean country mentioned in the listing that he has given. I've not heard it. So if he says that there are Caribbean countries that have been mentioned, I haven't heard you say that. So
Madam President, I cannot believe I stand up on a point of order. Unless
Senator, what is your point of order?
Senator Fede has just stood and said something that I don't want to, well, I cannot say certain things in this house. But it's just not true. I mean, I just went through the bill. I gave examples more than once of countries. I categorized them as Caribbean countries, and then I spoke about countries further afield. I mean, before Senator Fede stands and says, he should not do that, Madam President. I actually categorized the countries and I gave examples, and now he's saying that I did not mention a Caribbean country. May I repeat these examples, Madam President, with your permission?
Senator Fede, I will allow the senator because I think your information was incorrect. I specifically heard him mention Caribbean countries.
Deliberately so. We just sat there and allowed him.
Senator, would you just give the information and so we can...
Thank you, Madam President. Like I said earlier, from the Caribbean, jurisdictions with judge-alone trials. Antigua and Barbuda, Waipakuti.
Senator Ferdinand, please proceed.
Belize, Senator Fede, Belize, Cayman Islands, Jamaica, St. Kitts and Nevis, Trinidad and Tobago. I believe, Madam President, unless his geography is bad, these are countries from the Caribbean. I hope I have satisfied his desire to hear what he wanted to.
Senator Fede, the information has been reiterated for your benefit.
beg your pardon?
I asked Senator Ferdinand to please repeat the information for your benefit, so now you've done it.
So, Madam President, I did qualify by a statement by saying to the leader of government business that I didn't hear him say that. I never said that he didn't, but I did not hear. I heard Australia, I heard New Zealand. Okay? So, I'm very, very sorry, and I apologize to the leader of government business. But I want to say this, Madam President. The facts still remain, you know. The facts still remain that what we are trying to do here is to fast track a system that is in danger of compromising the quality of justice. Those facts are still there. So Madam President, I've asked a number of questions from our prison system.
Senator Daniel?
Madam President, I rise to seek some clarification from Senator Fede. Is he under the...
hold on a second. Senator Fede?
Yes.
Okay.
Is he under the impression that legislation to permit trial by judge alone is tantamount to an abolition of trial by jury? I'm just asking because I'm getting the impression that somewhere in there he is reading or he's interpreting, which I have not gotten the impression, that permitting trial by judge alone will lead to a complete abolition of trial by jury. So is that his impression? And if he is of that impression, maybe we can get further clarification from the leader of government business, because that is not the impression I got from listening to the debate in the lower house and from reading the bill.
Senator Fede, I'm sure you heard the question from the senator, please.
Yeah, my interpretation is, Madam President, is very clear, and what it says is that there are going to be instances, not in all instances, what I gather from what has been explained here today and what the amendment suggests, Not that there's going to be a complete abolition, but there is going to be instances where there is going to be trial by judge alone. That is what I've seen. And so if the government now Madam President, it is very important for the government to clear up all of those things, because I do hope that there's not confusion on the other side as to what they're trying to do. And I do hope that there's no confusion, Madam President, on the clarity and or the ramifications of what can possibly happen by attempting to do this, Madam President. And so therefore, we must make sure, I was making the point before I was interrupted, that all of our arms of government work efficiently. Our judiciary, Madam President, is an important pillar. Our executive, where the cabinet of ministers sit, that's an important pillar. Our parliament, that's an important pillar. And so, Madam President, just as it is as important for the judiciary to function well, we need the executive to function well. Because, Madam President, the budgets are often influenced and set by the executive for certain levels of the court, certainly at the High Court and at the Magistrate Court. The Parliament, Madam President, passes the laws and then hands them to the judiciary to interpret those laws. And so, Madam President, we cannot give the public of St. Lucia any indication that any of these are not working well in the dispensation of justice. And so therefore, I am very concerned when I see certain behaviors from government ministers. I am very concerned, Madam President. The Prime Minister went to a courtroom to say he came to see justice, that justice works. And that is in the Range Rover case with the CIP minister, when the case was effectively went to arbitration and was thrown out of the court. That kind of behavior shows that there is an unwanted intermingling between the executive and the judiciary. A prime minister who's the head of the executive goes to the judiciary, a courtroom, to say, I'm here to make sure that justice works. We cannot have that.
Ferdinand.
Madam President, I rise on a point of order, and I am
What is your point of
very
order,
deliberate
Senator?
in taking control of my own conduct. The member, Senator Fady, has once again imputed an improper motive against a member. Not just misled the House, because what he said is untrue, but has imputed an improper motive against a member of another chamber in the person of the Prime Minister. The Prime Minister has never gone into any courthouse. And what he just said never happened. I am leaving it at that, Madam President. I sit in a cabinet with the Prime Minister, and I am fully aware that he has never entered any courthouse to say anything in relation to anyone's case. Now, Madam President, this is a gross violation of the standing orders. The member has imputed an improper motive against a member of another chamber. And it is clear in the standing orders that he ought not to do so. And unless the member can prove what he just said, he should not repeat it, and it should be withdrawn from these records. This is a serious gross disrespect to the standing orders and an improper motive imputed against the member for Cassius East.
Senator Fady. The standing orders speaks to Section 37(4), that no senator shall impute improper motives to any member of either chamber. It shall be out of order to do so. I noted very carefully your utterance about the Prime Minister entering a courthouse to ensure him saying that justice is served. I would advise you that this information, I think, has imputed improper motive against the Prime Minister. I will give you that opportunity to either withdraw the statement or correct it.
Madam President, this is widely covered in the media. The Prime Minister said on television he's here to see that justice works.
Yes, he said it.
There could be no denial of that. And I'm not withdrawing it. It's factual. All of St. Lucia knows it.
Senator Fede.
I can't withdraw the facts.
Senator Fede, I am advising you to either withdraw this statement or correct it. Because I will have to ask you to provide the evidence to that information.
I certainly would be happy to provide the evidence that the Prime Minister is on record where he said, I am here to see that justice works. And that is at the sitting of the arbitration process regarding the Range Rover scandal of member for Castries South. That's factual.
Senator Ferdinand.
Madam President, I rise on the same point of order. The member has repeated an untruth in the presence of all of us. He started by saying that the Prime Minister went into a courtroom. Now he's saying that the Prime Minister made a statement. Madam President, the member has not withdrawn the first statement that the Prime Minister went into a courtroom. That is a serious allegation. I said that the Prime Minister never went into any courtroom to say anything. Now he has attempted to make a second allegation or a second wrong statement that the Prime Minister went to say that he came to see that. Madam President, neither one of these is correct. Both of these statements are wrong, and I am yet to see or hear Senator Fede withdraw either one of the two statements. I believe, Madam President, if he's allowed to continue with this, he will just continue on his merry way, and there is no recourse. It is not right for a member to do it. He has violated the standing orders, and he continues to refuse to withdraw. I don't know how we can permit that in this chamber, Madam.
Senator Ferdinand. Senator Ferdinand, please be guided with your comments. Please be guided with your comments. Senator Fede, I will give you one last chance to say to you to correct your statement or withdraw the statement that the Prime Minister entered a courtroom and indicated that he was there to see that justice is served. If you are not going to do that, I am sorry, but I will have to ask you to take your seat. Senator Ferdinand.
Thank you, Madam President. I will proceed to respond to the presentations made, and I want it to be noted for the second time in this chamber that a member prefers to discontinue and not speak than to withdraw an untruth and to speak the truth. But I'm going to speak the truth in response to some of what was shared in this chamber earlier. Madam President, I want to begin by establishing again the purpose for this amendment to the criminal justice legislation. The main purpose, like I did indicate when I presented the bill, was to improve the efficiency in the delivery of justice. And in improving the efficiency, one of the main benefits was to cut the time frame within which justice is dispensed. I think before the injustice that was done to the bill by Senator Fede, we heard quite a good or very insightful discourse and presentation by our colleague senator, and I took note of some of the observations that he made. I think it was clearly acknowledged that the bill is timely and it's important at this time. I think it is also important that we note the difference between a jury-type trial and a single, a judge-only trial. And it is clear, like Senator Daniel reiterated, that we are not attempting to replace the jury trial with the judge-only, but it is another option that is available to help to speed up the course of justice. So,
Senator Toussaint.
Thank you, Madam President, and I apologize, Leader of Government Business, that I'm interrupting your rebuttal. But based on what transpired previously, Madam President, I know it is within your remit as the presiding officer of the House to do so. But for my own clarification, perhaps, in the exchange between the Leader of Government Business and Leader of Opposition Business a while ago, I did note that you asked the member opposite to withdraw the statement, but that was not done. It means that as the Senate stands now, the statement is still a record in Hansard. And so I would like to ask that the statement be stricken off, because the member was not able to provide the clarification or the evidence to back up what he said, Madam President.
Noted, Senator Toussaint. Hold on a second. Thank you, Senator Toussaint. And noting that Senator Fede opted to not continue his presentation, rather than withdraw what Senator Ferdinand referred to as an interrupt. I am speaking. That will be stricken off the record of the Senate. Senator Fede.
Yeah, Madam President, just to clarify, I never opted to discontinue my presentation. You ruled that I sit down. That's a fundamental difference.
I asked you to withdraw that statement, or you may not proceed. You decided to not proceed, meaning you will not withdraw. Is it clear? Please proceed, Senator Ferdinand.
Thank you, Madam President. Sometimes I wonder if I'm in the chamber or if I'm at an infant school or somewhere. Let me continue. Madam President, I was making the point that the judge-only trial is not a replacement for the jury trial, nor does it cause the jury trial to be abolished. I think the comment that Senator Lee made with reference to Section 923, 7 and 8 are well noted, as well as 974B, 1 and 2. It is important that the increased confidence in the justice system be noted. And I think in some ways I found that apparently looking like it has been questioned by the opposition, because some of what was said was suggesting that putting that responsibility in the hand of a single individual can be problematic, and I think that's the point where the senator was attempting to suggest that there can be political interference when he made the accusation against the Prime Minister. So, Madam President, I want to say that in every jurisdiction we have systems, and in every system people run the systems. So in the executive, we have ministers and so on. In the legislature, we have senators and MPs. In the judiciary, we have judges, we have magistrates, and so on. If as a country, we do not have the confidence that the people entrusted with these responsibilities can dispense of them properly, then it's pointless having a system. We have people in here who want people to vote for them. They go out there and they say to people, vote for us. We are going to take care of the country. We're going to execute your business. But they have no confidence in people who have been trained and appointed to dispense justice. Madam President, I can see why the opposition, especially Senator Fede, has so much doubt. He has so much doubt, and he made a statement about the people not having any confidence in the politicians, and when they talk about politicians, what they think of politicians are. You see, Madam President, I can understand why he thinks so. Because if people have to look at the things that he says, when you hear people talking about flogging people, that is what people are going to think. When politicians talk about flogging people, what do you expect people to think of us? Well, I never said so. So you represent yourself when you say that. This is not a generalization that can be applied to everybody. So the conduct of a few individuals who are in politics does not represent the behavior and the disposition of all politicians. And I am not one of them. I'm excluding myself. And these things will never come out of my mouth, in the chamber or outside. And so some of the things that happen when some of our politicians open their mouths, like what just happened a while ago, is the reason why some of the people in this country have no confidence in politicians, especially politicians from his side of the chamber. Madam President, Senator Fede made a point about this being a solution to the problems we have in the criminal justice system. Madam President, from me, starting with me who presented the bill, and whoever else, Senator Lee who spoke on it, I did not hear anybody in this chamber suggest that this is a panacea or this is a solution to our criminal justice system. This is only one initiative that we believe will help to speed up the justice process and to make it more efficient. So again, the senator just creates his own argument as if someone made. Nobody said that. Nobody said that. Madam President, the halls of justice. So when the senator could not find anything relevant to debate on the bill, he jumps on the halls of justice. Can you imagine a member of this opposition coming to this chamber to talk about halls of justice? Why are we building a halls of justice? Why? What took us to that point? We are building this because we have not had a decent place to deal with matters relating to the judiciary, and we believe it is important that we do so. But we were not the ones who went around destroying the custody suites. Right. We did not put a bulldozer in it. Yes. That criminals or people who are accused cannot even be housed somewhere. And the member wants to talk about halls of justice. He forgot that it was a member of his previous cabinet that was it the Vatican? Making a big scandal out of the church, trying to create a conflict between the church and the government. I will say to the opposition, this government is not fighting with any church. That's right. We are not fighting with church. We will not fight with the Catholic Church or any church. We respect them, they respect us, and when there is any issue of conflict, we sit and we talk about it. We find solutions. We find ways to deal with it. And I believe that at this point, the church and the government have found a very amicable and mutually agreeable condition or situation with regard to the halls of justice. So we're not fighting with the church. And no opposition will cause this government to get into any fight with any church. Stop picking fights. We're not in that business. The National Trust can talk about fights with government. when they were in government. We are not fighting with the church. Madam President, let me wrap up, because I really felt that this last presentation pushed me to a limit that I haven't experienced in a long time. There was a mention of the idea of this bill not having been given enough time for consultation. When I stood today to present this bill, Madam President, I was presenting the second reading of this bill, which suggested that this bill had come to this House for first reading and allowed time for consultation. Now, we can always say that there could be more time for consultation, of course. But I always remind us, the opposition, that I did not come into this chamber in government. I came to this chamber in opposition. And I sat exactly where Senator Polius sat. And I remember on almost every occasion, every piece of legislation that was passed on this side at the time went through all three stages. All three stages.
Consultation.
And we were often lamenting on the fact that we need the government to give more consultation time. We are the government that has come to this chamber with the most pieces of legislation in our tenure that have not gone through all three stages in this chamber. And because I'm the leader of government business, I'm the one who stands up on standing order, is it 29-2 or 27-2, which one? To ask for bills to go through remaining stages. And today, for example, we have not passed a single piece of legislation that went through all three stages in this city. All three amendments and all three pieces of legislation today would have gone through, would have been put for first reading previous to today. So I find it very disingenuous for the opposition to make it seem as if we do not want to consult. We do that, and we've done it more than they have even considered doing it, and we will continue. When there is need for consultation, we will allow consultation. We will provide opportunity for consultation. And if we find there is need for more consultation, we will allow for more consultation. So, Madam President, I apologize if I seemed a little emotional earlier, but I think that there are times when I have to remind myself that I am sitting in the House in the House of Parliament, in the Senate, and that I am not in a playground where I have to be telling any child or any young person to behave. I'm honest, that's how I feel sometimes, and I have to remind myself, Senator, you are in the chamber, and this is not a playground. But I think sometimes we must remember that the business here is to come here and, as legislators, to discuss the business of the people of this country, and to do that in a way that is mature, responsible, and respectful. And Madam President, if I seemed emotional and a little bit agitated earlier, that was the reason. And so I want to go back to regular mode and say that I present this argument, and I hope that this bill helps to improve the speed with which and the efficiency with which justice is dispensed in this country. I thank you, Madam President.
Senators, the question is that the Criminal Code Amendment Bill be read a second time. I now put the question. As many as are of that opinion say aye. Aye. As many as are of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Criminal Code Cap 3.01.
Clause 2.
Interpretation.
Clause 2 stands part of the bill.
Aye.
Clause 3.
Amendment of Section 774.
Clause 3 stands part of the bill.
Aye.
Clause 4.
Amendment of Section 873.
Clause 4 stands part of the bill.
Aye.
Clause 5.
Substitution of Section 874.
Clause 5 stands part of the bill. Clause 6.
Insertion of new Section 874A.
Clause 6 stands part of the bill. Clause 7.
Substitution of Section 892.
Clause 7 stands part of the bill. Clause 8.
Amendment of Section 921.
Clause 8 stands part of the bill. Clause 9.
Amendment of Section 923.
Clause 9 stands part of the bill. Clause 10.
Insertion of new sections 974A and 974B.
Clause 10 stands part of the bill. Clause 11.
Insertion of new sections 998A and 998B.
Clause 11 stands part of the bill. Clause 12.
Substitution of Section 1018.
Clause 12 stands part of the bill. Clause 13.
Substitution of Section 1019.
Clause 13 stands part of the bill. Clause 14.
Substitution of Section 1020.
Clause 14 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Clause 1 stands part of the bill. Senators, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Senators, I beg to report that the Criminal Code Amendment Bill went through committee stage without amendments. Honorable Leader of Government Business.
Madam President, I move that the report of the committee be adopted and that the bill be read a third time and passed.
Senators, the question is that the report of the committee be adopted and that the Criminal Code Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Criminal Code Amendment Act 2025.
Honorable Leader of Government Business.
Madam President, I beg to present for second reading a bill shortly entitled Supreme Court Amendment. Unlike the first two bills, Madam President, this bill is here for second reading, had been previously presented for first reading. Madam President, the bill for consideration being the Supreme Court Amendment Bill seeks to amend the Supreme Court Act Cap 201. And that is in order to support the amendments in order to support the amendments made to the Criminal Code Cap 3.01. The Supreme Court Act Cap 201 requires certain amendments to give recognition to a trial by judge alone. And so, Madam President, the Act is amended to modify the definition of the word verdict to include the findings of a judge alone in a trial by a judge alone. As a result of this amendment, Sections 35 and 36 of the Act are amended to recognize the verdict of the judge alone in a judge alone trial in relation to the determination of an appeal in certain cases, the powers of the Court of Appeal, and in special cases. Madam President, further, Section 37 of the Act is amended to allow the Court of Appeal to recognize a verdict of a judge in a trial by the judge alone in dealing with an appeal against a special verdict that is allowed under Section 1019 of the Criminal Code. And so, Madam President, this amendment is to facilitate that purpose, and so I ask that it be presented and approved by the Senate for that purpose. I thank you, Madam.
Senators, the question is that the Supreme Court Amendment Bill be read a second time. Honorable Leader of Government Business. I shall pose the question. Senators, the question is that the Supreme Court Amendment Bill be read a second time. I now put the question. As many as have that opinion say aye. Aye. As many as have contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Supreme Court Act, Cap 2.01.
Clause 2.
Interpretation.
Clause 2 stands part of the bill.
Aye.
Clause 3.
Amendment of Section 2.
Clause 3 stands part of the bill.
Aye.
Clause 4.
Amendment of Section 35.
Clause 4 stands part of the bill.
Aye.
Clause 5.
Amendment of Section 36.
Clause 5 stands part of the bill.
Aye.
Clause 6.
Amendment of Section 37.
Clause 6 stands part of the bill.
Aye.
Clause 1.
Short title.
Clause 1 stands part of the bill. Aye. Senators, the question is that the committee rises and the bill be reported. I now put the question. As many as are of that opinion say aye. Aye. As many as are of a contrary opinion say no. I think the ayes have it. The ayes have it. Senators, the question is that the committee rises and the bill be reported. As many as have that opinion say aye. Aye. Beg your pardon, Senators. I think I want to move to the no. Senators, I beg to report that the Supreme Court Amendment Bill went through committee stage without amendments. Honorable Leader of Government Business.
A long day, Madam President. Madam President, I move that the report of the committee be adopted and that the bill be read a third time and passed.
Senators, the question is that the report of the committee be adopted and that the Supreme Court Amendment Bill be read a third time and passed. I now put the question. As many as have that opinion say aye. Aye. As many as have a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Supreme Court Amendment Act 2025.
Honorable Leader of Government Business.
Madam President, I move that the Senate will stand adjourned. Senate D.
Senators, the question is that this House do stand adjourned sine die. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Sitting adjourned. Thank you, Senators. Right.
we have just come to the end of today's Senate sitting for Tuesday, March 18th. Today, when the Senate convened, there were 3 bills down for consideration. After the resumption, the post-lunch resumption, 2 bills were considered, the Criminal Code Amendment Bill and the Supreme Court Amendment Bill. The Criminal Code Amendment Bill seeks to make allowances for trials to be conducted by judges only. In his presentation, the leader of government business had stated that the bill would complement the jury trial by jury, and that persons could have opted on whether it is a trial by jury they would prefer, or a trial by judge alone. He said, of course, that there were a lot of advantages to hosting a trial by a judge only. So the judge would have jurisdiction over the trial, and he would decide the guilt or innocence of the accused. But one of the main advantages that he pointed out of having a trial by judge alone was it would speed up the process of cases, and in effect it would clear off a backlog of cases that have just been sitting on the books. We saw a lot of back and forth, particularly from the leader of opposition business, Senator Dominic Fede. He felt that having a trial by judge only would somehow compromise the quality of justice. And he kept saying, the quality of justice couldn't be compromised, and there was a lot of back and forth. Of course, he spread his arguments to include so many other things, including the halls of justice and a lot of things. He said there was no discussion, and there was a lot of back and forth on that. Maybe you could add to that, Michael.
Oui, quand Virginie nous venu au bout de session avec session sénatoriale, c'est une chose ma preuve de service aller casser, mais un chai débat entre chef façade opposition et puis chef façade gouvernement en Sénat là. Qu'a discuté particulièrement ça, il a dit ce qu'ils ont fait code criminel là. Bon, il a été discuté l'autre semaine passée et puis c'est même concite là. Il partenait autant de débat comme ça. Mais quand même, ici à Jolia, et puis sénateur Dominique Fede, il menait l'autre bagaille entre quand il commençait et puis il a fait CIP et puis il commençait et puis il a fait Queen avec différents bagailles qui partaient chose. Il y en a ces bagailles nous changer, il commençait et puis c'est là il dit comme que le Premier ministre était allé supporter ça c'est assistant docteur Enesile à dans l'audience côté et puis ils a fait Range Rover, ça c'est machine Kassala avec il dit Premier ministre a tué aller dit comme que il allait à l'audience pour voir que justice faite avec ça il dit c'est ça qu'il fait, mais les sénateurs Dubian Ferdinand Dubout et dit c'est pas ça qui fait là, il changeait parole là. Avec ça continue jusqu'à temps, ça c'est président pour demander pour Dubout, puisque Dubout, c'est soit il Dubout, non, il prend parole à vivre. Eh bien, il Dubout en présentation. Avec c'est comme ça. Malgré après, il dit, il parlait Dubout, c'est lui qui m'a dit pour Dubout. Mais ça était intéressant puisque c'est en Halikase. En finissement quand même, nous, c'est sénateur Akedjian qui m'a dit, qui Dubout m'a dit pour ça. Pour parole à sortir pour tirer parole. Alors, c'est ça qui était plus intéressant. Avec là, même après ça, nous tenions l'autre
The Supreme Court Amendment.
Court là, il partait une discussion sur ça pour supporter ça.
Yes, so all the Supreme Court Amendment sought to do is to just make allowances to be able to accommodate the amendment to the criminal code where it would recognize a verdict given by a judge only. So this is it.
Merci un peu pour rester avec nous encore pour l'autre session Sénat là. Moi ça informé que semaine prochaine nous sommes ici encore pour présentation BGA. Eh bien nous avons merci ni en bonne soirée. Avec nous allons vivre maintenant en station pour plus d'informations sur ce qui est passé en gouvernement Saint-Lucie.
A good mixer, business mixer. It's a good thing I have